Welcome, ladies and gentlemen, to this 19th in the session of Coffee with the Bar, 19th in the series of Coffee with the Bar. Today we have a topic that would be of immense curiosity to most lawyers, and that is about the Supreme Court of Madras. The Supreme Court of Madras as an institution is something that most of us are unaware of, including lawyers. And it not only existed, it flourished, and it gave birth and rise to a lot of institutions, etc., indirectly. And we thought we must have a session about it, and the right person to talk about it was Mr. L Rajah. Preservation of heritage, heritage walks within the court, the history of the High Court, senior advocate, and one of the almost the founding members of the Consumer Action Group. When Mr. Rajah and me had a chat about what is the kind of title we would give for this session, as you are aware, we love to have these kind of double-edged titles which would give rise to a lot of speculation. So we were thinking we would probably title this as the Supreme Court that was right here at Madras. And we in fact had a hearty laugh as to how the title would be interpreted. Would some lawyers think of a bench of the Supreme Court now be coming to Madras and we are coming to talk about it? Well, I must tell you that we were not disappointed. I've had 3 people asking me the very same question. Now, without too much of lapse of time, Shri L Rajah speaking on the Supreme Court that was right here in Madras. Mr. Rajah, over to you.
Thank you, Sriram. Yes, you are right. Most people will think that this is a celebration of the fact that we have managed to open a bench of the Supreme Court at Madras, and people will be looking around to see where that bench is. There was a Supreme Court at Madras. It was a predecessor to the High Court of Judicature at Madras, and most people don't know about its existence. It's sad that most people don't know about its existence because much of the traditions of the bar, much of the functions of the courts that we follow even today, the roots of that were laid by the Supreme Court at Madras. So therefore, we have to know about it. Frankly, even I came to know that there had been an institution like the Supreme Court of Madras only about 10 or 15 years into practice. So I'm sure that it is not taught in law colleges. There is no necessity to learn about it. Therefore, it is a forgotten institution. But it is a very important institution, and we must remember. In fact, even some of the furniture that we use in the High Court are furniture that adorn the Supreme Court at Madras. But before I talk about the Supreme Court at Madras, I must also talk to you about the development of the legal system, at least briefly, and what led to the constitution of the Supreme Court at Madras. I think you have all heard me say that in 1639, when the British came to India, they had no territorial ambitions at all. They did not choose to be an imperial power. It was not in their mind to rule this great nation. They came here only as merchants. And for the simple reason that the price of pepper in London went up by £1, which they were then buying from the Dutch colony or the Dutch East India Company, that went up by £1. And therefore, the merchants in London petitioned the Queen and asked for a charter which would permit them to operate as merchants in India. First came into existence the East India Company, and from then on, it is a saga of how the British originally came in as merchants, then came in as forces that supported the intestine quarrel unfortunately, between the Indian rulers, and from then on, the East India Company became a territorial power and one of the first most successful multinational corporations in the world. And from then on, how the British government, being dissatisfied with the manner in which the East India Company was functioning, took on the mantle of governing this great nation. So, but obviously, I'm not going to travel all that long path. It is essential to emphasize that in 1639, when Fort St. George was the patron saint of England, as much as St. Patrick is the patron saint of Ireland, and St. David is the patron saint of Wales. St. George was the patron saint of England, and therefore the small settlement that started came to be called Fort St. George. Initially, the largest British settlement, the most prominent, of course, they were in Surat, they were in Machilipatnam, but the most prominent British settlement in India was at Madras. Then it shifted to Calcutta, and from Calcutta it went to Delhi. So in Madras is where all of modern India started. That's a different theme. And if you would happen to visit the museum, the photographic museum that we have established in the basement rooms of the lighthouse, you will find that there is an exhibition on this theme, which I'm saying this to kindle your curiosity. You must visit that and make a note of that aspect. Now, therefore, when the British to India as merchants, obviously you're not going to have a set of merchants dispensing justice. So setting up a court or setting up a system to dispense justice was far away from their minds. They didn't even attempt it. But as they went along, they found that it was quite inevitable that the task of dispensing justice was going to be thrusted on them. And therefore, slowly came the institutions that imparted justice. The first of it was in the form of the Corporation of Madras. As you would all know, that outside England, the second oldest corporation in the British colony is our Madras Corporation. It's the second oldest, right after the corporation in London. And even the oldest British building in all of Asia is our St. Mary's Church inside Fort St. George. So, therefore, the Madras Corporation also doubled up as a judicial authority. And the mayor and aldermen constituted the first sort of a court that came to dispense justice. Simultaneously, there was establishment of a few other courts, principally the Chowdhury courts, which was established to hear small claims. And then you had the Admiralty courts to administer justice to the pirates, as they were called. And then you had the mayor and his aldermen. And from the mayor and aldermen, an appeal would lie to the governor and council. This, very roughly, was the system that was in existence. But there were a lot of nuances. For example, initially, the jurisdiction of all these courts was only between Britishers. And then from that, it went on to render justice to all Europeans in Fort St. George and in the colonies that came to be within the jurisdiction of Fort St. George. And from that, it slowly widened and started exerting exerting its jurisdiction over the native Indians also. Initially, to be fair to the British, they did not want to impart justice to the native Indians because in the first place, they didn't understand what this was all about. The fundamental difference between British administered justice and the native justice system that was in existence in India was the native system of dispensing justice was a highly decentralized one. The panchayat was the center of dispensing justice, and many cases just stopped with the panchayat and never came to a higher appellate authority because social pressure ensured that these matters were not taken before an appellate authority. Whether it was good, whether it was bad, whether it was good to many of the oppressed classes, whether it was fair to women, are all large question marks. But the point remains that it was a very effective system of justice because there was prosperity, people did well, possibly social justice was not very prevalent. But the point is, it was a system that worked for the people. The British system is just the reverse. They centralized everything. They created institution in the presidency towns. They created institution in the districts. And from there, an appeal would lie to the presidency towns. So it was a complete ulta of the type of native justice system that was prevailing in India. And we slowly got acclimatized to that system, which is today prevailing all over the country. So when the British started rendering justice, it was a very, very incoherent experiment. People didn't know how to go about it. And therefore, this necessitated the issuance of various charters by the British monarch at every time when the British thought that they must improve the system that was already in existence. They went to the monarch issued a charter, and on the basis of that charter, various courts came to be established, including the Small Causes Court. And therefore, the system of justicing took various forms and shapes at various stages of history. Therefore, ultimately, the British were not very satisfied with the East India Company. The East India Company was also run by a group of officers who were famous and notorious for looting, not only India, but also the British East India Company. A company as successful and a company, a business proposition that could not fail, went almost bankrupt in the 1720s, the 1760s and the 1770s, and the British Crown had to come in and bail them out with a huge grant. When things reached this fast, Britain thought that the way out was to establish a Supreme Court at Madras, Supreme Court in India. So the first of the Supreme Courts that came to be established was the Supreme Court at Calcutta. The judges for the Supreme Court at Calcutta came to be directly imported from England. They had no touch with the basic native population, but what they did have is a sense of pride in the fact that they were direct representatives of the crown. And therefore, frequently the officers of East India Company and the judges of Supreme Court ran into headlong conflict. All of us would have read about the Nandakumar case, the Kasi Raja case. These were cases in Indian history which highlighted the deep differences between East India Company and the Supreme Court at Calcutta. And Supreme Court ultimately British East India Company wrote to the British Crown and said that, listen, we have borrowed a large amount of money from you. At some point of time, we have to return this money. And if you're going to set up a judiciary which acts as a stumbling block to everything that we do and makes governance impossible for us, we are not going to be in a position to return that money to you. So the British monarch started bringing out regulation which clipped the wings of the Supreme Court at Calcutta. So if the experiment at Calcutta had worked successfully, we would have very quickly also had a Supreme Court at Madras. But the fact that the Supreme Court at Calcutta did not function very successfully was the reason that the British government was not very keen on opening a Supreme Court at Madras nor a Supreme Court at Bombay. So they were sort of cooling their heels and wondering what to do about it. But in the meantime, East India Company started getting worse and worse. And frequently, there were conflicts between the mayor and the officers of the company. There is an excellent book by Henry Davison Lowe called Vestiges of Old Madras, which records British history in Madras. It's in 4 volumes. We have a copy of that in the Madras High Court Museum. And it records the history of Madras between 1640 to 1800. In that, Henry Davison Lowe records the fact that in the late 18th century in Madras, there were the following 4 practitioners of law: Charles Bromley, John Sykes, Stephen Popham, who was responsible for developing that Broadway area, and Thomas Jones. The last of them, Thomas Jones, acquired the notorious reputation for being the first advocate to be struck off the rolls for acts of unprofessional conduct. And this is what, on 5th June 1784, the company records. The notoriety of the charge alleged against Mr. Jones, besides his contemptuous behavior towards the authority of this government on a former occasion, rendered it, in our opinion, proper to inflict some mark of our displeasure upon him. And at a court of appeal held on 19th February, we accordingly passed a resolution incapacitating him from practicing as a solicitor in that court. So this gentleman, Thomas Jones, was the first person to be incapacitated from practicing law in Madras presidency. Now, Thomas Jones was actually a representative of that class of advocates who was sort of encouraging the mayor and his aldermen to get on to a headlong collision with the East India Company. One Tariano, for example, who happened to be a secretary to the government, wagered a bet with one Nice, who was the mayor of the Corporation of Chennai. Both of them were pitch drunk at a party, and then they entered into a wager, and the mayor lost that bet. So next morning, Storiano decided that he will demand the money that the mayor had lost to him. So he wrote a notice. He sent a notice to the mayor demanding the money. The mayor refused to make the payment, and Storiano immediately filed a proceeding before the mayor's court, asking for the mayor to make the payment to him. And the mayor ruled that the mayor was beyond, had complete immunity, both in civil and criminal proceedings, and therefore he was not bound to honor any problem. So these are things that irritated the British Crown. And the long and short of all this was that they decided that there has to be some sort of a reformation. And they chose one of the finest people to do this actual task of reforming the justice system. And they located Sir Thomas Strange, who was then in Nova Scotia in Canada, and brought him down to Madras and charged him with trying to reform this system. Thomas Strange was initially charged with trying to create what is called a recorder's code. So Thomas Strange said, yes, I will constitute a recorder's code. And the recorder's code was constituted in 1798. But what Sir Thomas Strange disliked was the fact that these very same aldermen, whom he considered to be absolute bandicoots, were sitting with him as judges of the recorder's court also. So he had had enough. He wrote to the British Crown and said that, listen, if you want a decent system of justicing in Madras, you will have to separate commercial interest from this task of justicing. All these aldermen have an interest in many of the litigations that come up before them. This is not healthy for the system of justicing that we need to set in place, and we need to have a more refined system of justicing. So the British gave him the passport to create the Supreme Court at Madras, and the Supreme Court at Madras came to be. So that is how the Supreme Court at Madras was established. And I must tell you at this point of time, there's one very important thing that you must know, that at this point of time in history, there was slowly emerging a class of British men whom I would call Anglophiles. Now, previous to Sir Thomas Strange, and Sir Thomas Strange himself belonged to a category whom I would call Orientalists. These Orientalists held the belief that you must not do anything to disrupt the basic Indian system of life. You must not do anything to disrupt this ancient civilization. If at all, the British Crown must establish systems that supplement this great civilization. So this bunch of Englishmen came to be called Orientalists. Principal among them was Warren Hastings, who established the Calcutta Madrasa and encouraged the officers of East India Company to learn Persian and Arabic. Jonathan Duncan, who established the Sanskrit College in Benares. Lord Wellesley, who directed the company officers to learn Arabic, Persian, and Sanskrit. Lord Amherst, who established the Sanskrit College in Calcutta in 1824 and the Sanskrit College in Delhi in 1825. And of course, the most glorious of them all, Sir William Jones. Sir William Jones joined the British service as a judge of the Calcutta Supreme Court, but then his interest went much beyond that. He actually learned Sanskrit, he learned Persian, he learned Arabic, he translated Kalidasa Saguntalam from Sanskrit to English. He translated Kalidasa's Ritu Samhara from Sanskrit to English. He translated Manu Samhita to English, and uh, he was the founder of one of the greatest societies which exist even today, which is a repository of Indian culture, Indian refinement, and Indian civilization, which is the Asiatic Society at Calcutta. So he was the founder, along, of course, with a lot of help that the rulers gave him. He was responsible for establishing that society. And of course, even today, when you go to St. Paul's Cathedral in Rome, you will find a statue of Sir William Jones with a book in his hand. And you look closely at the books, it is written Laws of Manu. So one of the greatest works that he did was to actually learn Sanskrit and to translate all these works into English and to tell the Englishmen that, listen, these are not Philistines. These are not barbarians. This is a very advanced culture, and you must respect this culture and civilization and do nothing to interfere with it. Of the same ilk were people like H.T. Colebrook, who wrote a translation of the book Ambaroksha from Sanskrit, and Sir Alexander Johnston. Alexander Johnston learned Tamil, Telugu, Hindustani, and opened a branch of the Asiatic College in Sri Lanka. So these were a bunch of people who were Orientalists. And Sir Thomas Strange also belonged to that category. He felt that Indian civilization is something that has to be preserved. Indian civilization is something that has to be respected. Don't meddle with it. Don't do things that would disrupt their way of life. But from later, you had another class of Englishmen who started emerging. And formidable in that class was Macaulay. Babington Macaulay came to India, and India was then never the same again. He, in one short sentence, with absolute arrogance, but unfortunately total conviction, he said that a chapter in Gulliver's Travels of Robinson Crusoe is equal to all the learning that you have in Sanskrit. That is the disdain he had for Indian civilization. Of course, there are statements from him in the Legal Minutiae where he also extols the Indian way of life, where he says, I've traveled all over the country and have never seen a beggar, etc., etc. But primarily, he did not acquaint himself with learning with the Sanskrit literature or Urdu classics or Persian classics or Arabic classics or in any of the Indian languages, but was completely disdainful of all that was Indian. And he felt that the only way in which the British could effectively rule India was to substitute the ancient systems of learning with the British system of education. Effectively, from a civilization which was creative, from a civilization which was prodigious in its output of in art, in music, in science, and in any major walk of life that you could name. From that stage, we became glorified clerks, right? So that happened by introduction of the English system of education by Babington Macaulay. He was a fantastic legal mind, and even Mr. Palkiwala had occasion to talk about his prodigious memory. And he was, of course, a phenomenal person. But what he did, the manner in which he harmed India, was to introduce the British system of education in India, and India thereafter was never the same again. But Thomas Strange wanted to preserve all that was good about India. He respected India, and he set in place a system that that challenged the absolute corruption of the Mayor's Court. And when he took charge as the first Chief Justice of the Supreme Court of Madras, he came into headlong collision with the mayor, a person called William Abbott, who was an arch schemer. He did everything under the sun to ensure that the Supreme Court of Madras would collapse as an experiment, and the British would never again think of constituting a British court. But Sir Thomas Strange was a fighter. He took these people head on and ensured that the mayor's court and the aldermen were put in place. He introduced honesty and a great sense of justice to this task of dispensing justice. But he knew his limits. The judiciary today is not the judiciary that existed when the Supreme Court of Madras was constituted. The Supreme Court of Madras in 1800, when it was constituted, still there was no great dividing line between the judiciary and the executive, and their functions many times overlap. In fact, quite amusingly, you know what the British used to do earlier, before they passed a legislation, before they placed a bill in the assembly, a copy of that bill would be sent to the Madras High Court. I'm talking about just before independence. And the judges would be asked to give their comment on the bills before it was placed in the assembly. This was ensured because at a later date, they didn't put themselves in an embarrassing position when the court said we will not implement this law. So they had a system where they sent the bill to the High Court, and the High Court would form a small committee of judges. The committee would look at the provisions of the bill and give their opinion. And if there were to be any changes in the bill, those bills would be changed. But you know, even after writing my book on the Madras High Court, I was very amused to find that the Assembly still sends a copy of the bill to the Madras High Court before it is placed before the Assembly and before it is being passed. And so I asked the registrar, "Now why he says, I don't know, sir. I receive the bill, I take it and keep it and file it." So, you know, these are old systems that were in existence. And when Sir Thomas Strange was actually the Chief Justice of Madras, he understood his limitations and said that, yes, I may be a representative of the crown, unlike the judges, like Sir Elia MP, who gave the word impeachment because the British then tried to impeach him, who gave the word impeachment to the dictionary. As against Elia MP, the Thomas Strange was aware of his limitations, but still functioned wonderfully within those limitations. And that was what was great about him. He had a brother judge, Justice Gwilym. I recently helped a scholar from London to do some research on this wonderful gentleman. Gwilym, on the other hand, thought that he had powers above the executive. So after the Sepoy mutiny, it was he who demanded that, listen, chaps, you have gone and arrested a whole lot of people as conspirators to the great Sepoy mutiny. Why are you not producing them before court? You today have a requirement in law that a person arrested must be produced before court in 24 hours. Now, Gwilym was the first person who demanded that that principle and rule must be put in practice. And he became such a nuisance for the British crown that they called him back and sent him back to England in 1810. So I at least had the satisfaction of working with a British scholar to send a lot of stuff here from the archives in Madras for a chapter which that gentleman was writing about this great Justice Gwilym. So these were the champions of liberty. These were the champions of freedom, even within the framework of the executive controlled judiciary, I should say. So this is a picture of the Supreme Court at Madras. This is the building where it first existed. And you will see what a beautiful building it was. It was on the first line beach at Madras. Can I have the next slide? I think some of you may have seen this building. This is the portion which actually was the Supreme Court. And you will see a small cupola in the front. And that is what remains of this building, because with our great sense of heritage values, we went and demolished this building sometime in 1981. Now, all that now in this place now stands the Singaravelar Maligai in first line beach, Madras, and all that remains of this glorious building is the cupola in front. Even now, if you go to Singaravelar Maligai, you will see that small cupola in front. That's all remains of this wonderful building. It was also the place where the collector of Madras functioned from. And I understand some of the appeals from the customs cases used to come up here. So there are quite a few advocates who would have had an opportunity to visit the building in those days, though it was much before I joined the profession. So this building is the building that housed the Supreme Court of Madras from 1817 till 1892. It is only in 1892 that the Madras High Court building came into existence. And before that, it functioned, even Madras High Court for a good 30 years functioned only from this building. Can I go to the next slide? This is all we have it's a wood sketch or a carving in wood of the interior of the Supreme Court at Madras. So you will see the costumes of people who are assembled there. You will see the dress of the clerks. You'll see the arrangement before the court. And as I said, much of the furniture that you had there is still being used by us at the Madras High Court because it was all sturdy stuff. This is where it all started, so to say. Now, the interesting thing about Sir Thomas Strange is I told you he was an Orientalist. So he was very intrigued by the system of justice in India. Of course, as far as cases relating to the Muslim community are concerned, much of it used to be dealt with by the community itself. They hardly came to court. And therefore, it is their holy men who will rule on any conflict. And much of it, therefore, stayed within the community. It hardly spilled over to the courts. But as far as Hindu conflicts among Hindus were concerned, they did come to court. And Sir Thomas Strange used to make notes of all these cases. And after he retired, he wrote a book on elements of Hindu law. And that became a very popular book, and he wanted to write a second volume of this book. But when he wanted to write a second volume of the book, and he wrote to all his companions and friends in Madras, none of them wrote back and gave him any material. He wanted to know about the advancement of law on various principles that he had laid down, but he received no help from anybody at Madras. And the second edition of his book, which was written in 1829, remarks that much as I had tried to get some information about the advancement in law in India, unfortunately, help has been wanting. So he says, I owe no thanks to anybody, for I understand that even the sun has no value after it has set. So he was one of the persons who understood very early that a judge, after he retired, had no value at all. And he records that in his book as a sad footnote. Then you had the next judge of Madras, Sir. And there is one very famous painting. It's a painting very famous all over the world. The holy men outside the house of Sir Thomas Strange. We have the next slide. Yes, this is a very famous painting displayed at one of the world famous museums. This is a painting of holy men outside Sir Thomas Strange's house. Frequently, he will have interactions with holy men to understand how the scriptures must be interpreted, how the law must be laid down, what are the various principles laid down in the Smritis, how those principles must be applied when there was a custom and usage which were against those Smritis. So this inquiry was an ongoing inquiry as far as his legal mind was concerned. And that is how I managed to get a copy of that book from the Madras archives, and I have presented a copy to the Madras High Court Library and also to our MBA library. Elements of Hindu Law, therefore, came to be the first book on Hindu law written by a judge of the Supreme Court of Madras. His successor was Sir John Henry Newbold. To the inhabitants of Madras, the second Chief Justice of Madras was a familiar figure because even earlier he had been a puisne judge of the Madras High Court. On assuming office, Sir John Newbold found that he was head of an elaborate staff. Now, just look at the staff that the Supreme Court of Madras had in 1850. Whom did the court have? The court had a sheriff, it had a deputy sheriff, it had a coroner, it had a master in equity, it had a registrar, it had a proto notary, it had a deputy registrar, it had a clerk of the crown, it had an accountant general, it had an examiner, it had a sealer, it had a clerk to the Chief Justice, then it had clerks to the puisne judges, then it had a crier, then it had interpreters in, please note these languages, French, Dutch, Armenian, Persian, Hindustani, Gentoo. Gentoo is, Telugu used to be called Gentoo. Originally, Gentoo used to denote Hindus, but in Madras province presidency, Gentoo was referred to also the Telugu speaking people. Malabar, Canaries, Portuguese, and Malayalam. So you had to have an interpreter for all these languages because the jurisdiction of the Supreme Court, as was the jurisdiction of the Madras High Court, extended from the end of Orissa to the shores of Kanyakumari. And it included large parts of Andhra Pradesh, except for the kingdom of the Nizam of Hyderabad, large parts of Karnataka, except for the kingdom of the Maharaja of Mysore, large parts of Kerala, except, of course, the kingdom of the Travancore Maharaja, large parts of Tamil Nadu, except for the principalities of Raja of Pudukkottai, Raja of Sivaganga, all of whom had their own courts. So, and then it had French merchants, it had Dutch merchants, it had Portuguese merchants, it had Spanish merchants, and therefore when disputes arose before the court, it needed this whole range of interpreters. And Sir John Henry Newbold found that as much as Sir Thomas Strange was a great person, and he was trying to set right the systems and was trying to lessen the damage caused by the mayor and aldermen, the court and its officers themselves were becoming corrupt, because Sir Thomas Strange's attention was all on the mayor and the aldermen, the corporation, the various East India Company officers, etc. He never imagined that the court which he had established, their officers themselves will become corrupt. Sir John Henry Newbolt, on the other hand, was a very, very astute administrator, and he understood there was something terribly wrong going on at the section. And one of the persons who was responsible for much of this corruption in the judicial institution was a registrar called Gilbert Ricketts. Gilbert Ricketts lived in the place where the present Raj Bhavan is. That was his home. So you can imagine the type of estate that he lived in. And to his, ill luck, he invited one of the puisne judges of the Supreme Court, Sir Edmund Stanley, to his house for dinner. And he hosted a lavish dinner for Sir Edmund Stanley. And one of his friends, I don't know, probably he never called him a friend after that, invited Sir Edward Stanley to also come and take a look at the stables. So, Sir Edmund Stanley went and took a look at the stables, and he was amazed to look at the range of the Arabian steeds and the type of horses that were parked there in the stables. I mean, you assume that there is a dinner hosted by one of the registrars, and you go to his house and you find some Benz car parked in his parking place. It will raise a question mark. And sure enough, for Sir Edmund Stanley, it raised a question mark as to the salary of a registrar. Okay, salary of a registrar in those days was quite handsome, but even that, how did he? And unfortunately for Gilbert Ricketts, Sir Edmund Stanley happened to be an arithmetician. He was a mathematician also. So he put 2 to 2 together and said it doesn't add up. So he told the Chief Justice that we must constitute an inquiry into what is going on. And Sir John Henry Newbold and Edmund Stanley wrote to this gentleman and say that, listen, we want details of all the monies that are coming in and how that is. One of the very easy ways in which the registrar could swindle money is large estate. You know the principle of a sheet. When there is when a large estate is without a heir, the government could take over, in theory, that large estate. And there were also a lot of monies that were collected in the name of the estate, which were required to be deposited in court. So the registrars would keep swindling that money and keep using that money, and would use that money and lend that money and make interest on that money and return the capital back to the account. All these shady things were going on. So Sir John Henry Newbold and Sir Edmund Stanley asked this gentleman, come on now, you give us the accounts. And Gilbert Ricketts appeared with the accounts. Externally, he appeared to be very composed. He took the accounts in his hand. And as he walked up to the desk to submit the details to the 2 judges, he fell down flat and died of a massive cardiac arrest. Now, that sent ripples right through the judicial staff in the Supreme Court, and they understood that the judiciary was not going to put up with all this nonsense, and that you had to have a system that was above reproach, was extremely efficient, honest, and that the judiciary was looking to people of integrity. So came to be that the Supreme Court then transformed itself into a most vibrant institution containing men of character, integrity, efficiency, and set very high standards of prudence and conduct, good conduct. So Sir John Henry Newbold was largely responsible for that happening. Then you had the third Chief Justice of the Supreme Court, who was Sir Edmund Stanley. Edmund Stanley, once again, one of the things that you must understand about the Supreme Court of Madras and the even the Madras High Court is the feeder category, so to say, came from the islands of Penang. It used to be called the Prince of Wales Island. And many of the judges of the High Court and many of the Chief Justices of the High Court have had at least a brief sojourn in these islands before they took charge as the Chief Justice of the Madras High Court or as a puisne judge of the Madras High Court. Sir Edmund Stanley was no exception. He first served as a judge in the Prince of Wales Islands. He was absolutely distinguished service. The British were very happy with him and then sent him to Madras. So in some way, these smaller colonies were actually crucibles in which the metal of these judges would be tested before they were transferred and were appointed to Madras. This is why Madras Presidency, the Supreme Court at Madras, and the High Court at Madras came to have some of the finest legal minds as their officers, because prior to coming to Madras, they had already spent time in various other courts in British colonies where their efficiency, their values, their integrity had already been tested before they came to Madras. So obviously their standards were remarkable, and Sir Edmund Stanley was no exception. He had a faultless reputation. Interestingly, at the time that he joined the Supreme Court at Madras, Sir Samuel Toller was the company's Advocate General, and there were just about 6 barristers practicing at Madras. And interestingly, we also have the names of people who were functioning as interpreters at Madras, and it is he who introduced the tradition of mace bearers for the High Court. This tradition of mace bearers used to exist in Ireland. There they used to be called as tipstaff. Today, even in Ireland, even today, you have these tipstaffs who walk in front of the judges. Only thing is there they don't have so many people as we have. So the tipstaff usually doubles as a driver. He comes as a driver to the judge, and then when he reaches the court, he pulls out a mace and starts stuttering in front of the judge. So he introduced the system of tipstaff into the court. And he was also a judge who was all heart, because in about 1824 to 1826, Madras was going through a tremendous period of drought. People did not even have food to eat. And it is to his account of his efforts that the government played a major role in ensuring that the poor were fed, that facilities were created for taking care of the downtrodden. And at the time that he retired, it is the people of Madras who gave him a farewell, more than the formal, farewell address by the Advocate General and the bar. The people of Madras organized a farewell for the Chief Justice. And thereafter, that also came to be a standard by which you could assess the effectiveness of a judge. Because any judge who had a farewell by the people of that particular presidency was satisfied that he had done a good job. Similarly, you had Sir John Peter Grant in Bombay. The British Crown refused to honor a writ of habeas corpus that he had issued. And that writ of habeas corpus was to release an Indian who had been arrested. The British Crown refused to give effect to that and refused to honor that. So in protest against that, Sir John Peter Grant closed the Supreme Court of Bombay for 6 months. He said the British had no business. He said, what is the point in constituting the judicial office and getting me to pass orders if you're not going to obey the orders that I pass? So Sir John Peter Grant was held in great esteem by the citizens of Bombay. And it is said that on his retirement, they gave him a very hearty farewell. And as he got into his chariot to leave, they fed the horses and took the citizens drew the chariot and took the judge to the port from where he boarded a ship to leave for England. So that is the type of, that's why I said these are the classes of Orientalists who had such love for India, who appreciated Indian culture, who had love for the Indian people, and were in turn loved and respected by the Indians themselves. The fourth Chief Justice of India was a gentleman called, of the Supreme Court of Madras, was a gentleman called Sir Ralph Palmer. See, he was the first person who understood that this business of independence of the bar was all a myth unless you provided some sort of an earning capacity to the people who were practicing in the bar. He felt that without economic independence, there can never be real true independence of the bar. And it is from his time that advocates were given offices as receivers, advocates, barristers were given offices as assignees, and they were given some sort of a part-time work because he was very convinced that unless people had some sort of a sustenance, they would have to be completely at the beck and calling of the judiciary, which was not good for the independence of the bar. And it is he who started that. Unfortunately, I have heard my senior Mr. Govind Swaminathan say that the British judges and the Indian judges would keenly follow the working of juniors, and when they found that certain juniors were good, they would give them receivership, that they would give them some work as an assignee, they would put them in some sort of a position which ensured that they had some income, and will also be a process by which they can monitor the progress of that young, bright youngster. So this was the method which was actually put in practice by this gentleman, Sir Ralph Palmer, and for that the bar was completely indebted to him. It was also to his credit that for the first time he recognized the principle that there could be a probate of an Indian's will also. See, there was this problem which arose frequently before the Supreme Court, that according to ancient Hindu law, there was no concept of a will. But as more and more people started serving the British, primarily the Dubashas were agents on both sides, right? They were agents for the British, they were also agents for the Indians on whose behalf they were negotiating. So when these Dubashas, principally Pachayappa Mudaliyar, when he passed away in 1794, he left a will with a huge extent of property which was covered under the will. So the question arose as to whether a probate of an Indian's will could be, a Hindu's will could be granted. And Sir Thomas Strange had laid down the law that there could never be a probate of a will made by a Hindu, because Hindu law does not recognize the execution of wills. And it is to the credit of Sir Ralph Palmer as a fourth Chief Justice of the Supreme Court of India that he overturned that position of law and granted, in the famous case of Advocate General versus Annasamy Pillai, he granted will, the probate of the will of Pachayappa Mudaliyar, which then paved the way for this Pachayappa Mudaliyar charities to be established, for Pachayappa's College to be established, and the several charities which that great institution does even today. One of the redeeming features during his time was the arrival of George Norton. The amount of contribution that the Norton family has done for Madras, especially in terms of legal education, in improving the quality of the bar, in helping Indians seek self-governance, is stupendous. And George Norton also started this practice of having on every Saturday a class in his house where he taught law, where he found, because he found that the bar was infested with barristers and attorneys, and there was no space for Indian talent to come in. He wanted Indian talent to come into the bar, and therefore paved the way for doing that by holding classes. Sir, he also assisted the Chief Justice in inducting a large number of Indians into this, into the judicial institutions. So that was the those were the contributions of the fourth Chief Justice of the Supreme Court of Madras. So we will come to the fifth Chief Justice of the Supreme Court of Madras, a very gruff and what was a bit of, he must have been a bit of a Sidumunji, basically. And this was Sir Robert Buckley Common. So in the first place, but he was a good academic, and he started his career as being an academic. He wrote a book on the treatise on usury in 1817, which received rave reviews. It is on the basis of that he took oath as the Chief Justice of the Supreme Court to the accompaniment of 15 gun salutes. See, all the gradation of honor in the British regime would be on the basis of the gun salutes that you receive, right? Even the royalty, if you had to be very high. You had to be the Maharaja of Travancore for you to receive a 22 gun salute. And smaller principalities would receive a 7 gun salute or a 9 gun salute. And if the British were not happy with the Maharaja, they would degrade him to a 15 gun salute. So, therefore, you are ranked on the basis of the gun salutes that you receive. And the Supreme Court judges used to receive a 15 gun salute. Common also wrote a book on treatise on the law of landlord and tenants, and which also received rave reviews on the basis of his academic work that he came to be posted here in the Madras High Court. He had a gruff and a bit of an arrogant bachelor. He didn't marry. No wonder, I don't think anybody would have found him very attractive. But what he did was that he found time hanging on his hands. You must understand that that point of time in Supreme Court, the Supreme Court functioned for only 16 weeks in a year. 2 weeks in February, 4 weeks in March and April, about 4 to 5 weeks in July, August, and then the last stretch in September to October. So totally, it would only work for 16 weeks in a year. So most of these judges found time hanging on their hands heavily, and therefore wanted to contribute to society, wanted to do something for society, and Common felt that, you know, all these British officers, many of the British officers are far away from home. Many of the judges don't know what to do in the evening. So he mooted the idea of starting a club in Madras. And it is on the basis of that suggestion that the Madras Club came to be established. Even today, you go and look at the minutes of the club, it will show that the first committee meeting of the club was held under the presidentship of Sir Robert Common. And he was the judge of the Madras High Court, the Supreme Court at Madras, who started the Madras Club. And many officers then joined the Madras Club. When it was first started, its home was at what Express Estates is now. The lovely building that existed there. And that is where Madras Club started. Then for some time, it shifted to, I think, the Rajah of Borbley's residence somewhere on Poonamallee Road. And it now is housed the present club where it is. So he was responsible for starting the Madras Club, which is referred to as the Ace of Clubs. Unfortunately, what actually happened was this Robert Common became very enamored by the Roman route. So he was an academic, he was a scholar, and he started writing the book, which was a very well-regarded book, History of the Western Empire, from restoration of Charlemagne to the accession of Charles V. So the more and more he read about the Roman emperors, he wanted to cast himself in the mold of those Roman emperors. And he was the first of, you know, I told you about the 3 classes of British. The first, Orientalists; the second, the Anglophiles. Robert Common heralded the arrival of the 3rd class of British judges, or British gentlemen, who you could refer to as imperialists. They strongly started believing about the superiority of the British and in the superiority of the position that he himself held. So from then on, he would not brook any dissidents, and he had a tough time with his puny judge, who was Edward Gambier. And both of them, in full glare of the public, went into a conflict about the appointment of the registrar of the Supreme Court, with Gambier putting his foot down and saying that the person that whom you propose to appoint is completely useless for that post. And Common just looked at him silently and told the registrar that please come and join duty from tomorrow, you are appointed. So that unfortunately soured the pitch for the administration of justice in Madras, because these two judges could not get on with each other at all. After Commons period came to an end, he did not receive any farewell. No, most people are quite glad to see him go. And after he left, obviously, Sir John Gambier stepped into his shoes. He was also of an academic bent of mind, and his book on a treatise on parochial settlement held sway for a long time. He also came from the Prince of Wales Islands, which is Penang, and was inducted as a Chief Justice of the Supreme Court at Madras. He also realized that there had to be economic independence for the bar to be truly helpful in the administration of justice. He felt that advocates who were extremely servile to the judiciary, were extremely servile to the executive, contributed nothing at all to the progress of law, contributed nothing at all to the systems that we have established. And therefore, the first thing that he did as soon as he took charge, he revised the table of fees for advocates and ensured that they get higher fees in the matters in which they appear. So obviously the bar must have loved him a great deal. And it is to his credit that he started also recognizing Indian talent. And one of the talents that he recognized was C.V. Ranganath Sastry. He was floored by C.V. Ranganath Sastry, who knew 14 languages. If you had observed, from 1800 to 1862, I have still not mentioned a single Indian name. This is the first Indian name that I am first mentioning. So C.V. Ranganath Sastry was the first Indian to have been recognized by the British, who were completely floored with this man's knowledge of various languages, his efficiency, and therefore they made him a judge of the Small Causes Court. The first judge to be made Chief Justice of a Small Causes Court was Sir C.V. Ranganath Sastry. And with his wife, you see, in those times, since there was no great differentiation between the executive, the legislature, and the judiciary was also the center point of social life in Madras. Many of the Chief Justices of Madras were patrons of art, patrons of various fine arts, and a great, propounders of social movements, I would say. And it all happened. Can you post that picture of Brodie's Castle? Brodie's Castle. This is Brodie's Castle. This Brodie's Castle was the center of social life in Madras when Sir Thomas Strange was its Chief Justice. Interestingly, the first Chief Justice of the Supreme Court at Madras, today it is the Music College. Can you show the next slide? This is what it is today. Of course, today it's a little different from what you can see in this picture. But this is on the banks of River Adayar and was the house of Sir Thomas Strange. Many parties used to be held here. Many balls used to be held here. And it was all a very glittering scene that happened. And many judges took it on themselves to energize the social life in Madras. And Brodie's Castle, thankfully, is still in existence. Brodie's Castle, as I mentioned to you, was the house of the first Chief Justice of the Supreme Court at Madras. Interestingly, it was also the house of the last Chief Justice of the Madras High Court. Justice Gentle, who was the last Chief Justice of the Madras High Court, also resided in Brodie's Castle. But between this time, various Chief Justices have lived in various different places in Madras. Some of these houses do exist today, some of them don't exist today. For example, Justice Edward Gambier lived in a place called Gambier's Garden. Many judges lived in Mowbray's Gardens. Some of them also lived in Harrington Road. So these residences would change. And but primarily, they were also the center of social life at Madras. Then you come to the seventh Chief Justice of the Supreme Court at Madras, Sir Christopher Rawlinson. He was also basically an academic, and he wrote the book, the Municipal Practices Act. Um, 1847 proved to be a very important year in the life of Sir Christopher Rawlinson, because in that year, he lost his father, gained a wife, was knighted by the British Crown, and left England to come to India. All this happened in 1847. And the person who ought to have been elevated in his place is a judge called Sir William Burton. But William Burton, though a completely affectionate person, was full of eccentricities. What he used to do on days that he came late to court, he wouldn't go to the court straight away. He would go to his chambers, and from his chambers, he would go to the sheriff's office. And the sheriff's office, he would pay a fine to the sheriff for coming late and then take his place in the court. Now, these types of eccentricities the British were not very happy with, and therefore they superseded him and they made Sir Christopher Rawlinson as the Chief Justice of the Supreme Court of Madras. But to his credit, he never bore any grudge against Sir Christopher Rawlinson. He was supposed to have been one of the most adorable and gentle judges of the Supreme Court of Madras, and it is on account of his help that Sir Christopher Rawlinson was able to do a lot of good things for Madras. Primarily, his greatest contribution was in getting the government to start the Madras University. And he was the first Chief Justice of the Supreme Court of Madras, who was the first Vice Chancellor of the Madras University. Even today, when you go to the Madras University, you will find in the roll of honors that Sir Rawlinson is the first Vice Chancellor of Madras University. Actually, if you, from 1857 to 1920, if you take that period, the maximum number of Vice Chancellors have come from the legal profession. They had either been judges of the Supreme Court of Madras, or had been Chief Justices of the Supreme Court of Madras, or had been judges of the Madras High Court. In fact, the first Indian to be made a Vice Chancellor of the Madras University was Subramanian Iyer, who was once again a judge of the Madras High Court, and the first government leader, Indian government leader of the Madras High Court. So this connection that Madras University had with the judiciary and with the bar was a most glorious one, and it existed for nearly 50 to 55 years. And much of what Madras University is today is owing to the tremendously tall men who led them during this period. Therefore, Sir Christopher Rawlinson's greatest contribution is the fact that he established the Madras University and also established the system of legal education. Then we come to the last Chief Justice of the Supreme Court at Madras, Sir Henry Davison. Sir Henry Davison, again, was an academic, but interestingly a different type of academic. He, for the first time, was an academic who rose into prominence on account of running very successfully a law report. He established a law report called Davison and Merville's law reports, and then another set of law reports called Gale and Davison's law reports. He was a great socialite and was a very intimate friend of the very famous Indian, the British writer William Makepeace Thackeray. William Makepeace Thackeray has in fact dedicated a book in memory of a Chief Justice of the Supreme Court of Madras, Sir Henry Davison, which is called The Virginians, A Tale of the Last Century. Interestingly, Sir Henry Davison holds a unique honor of having been the Chief Justice of the Supreme Court at Madras, and for a brief period also as the Chief Justice of the Supreme Court at Bombay. And then he was sent back to Madras, where he retired from Madras. He was also a great, I would say, a supporter of the Madras Literary Society. Can we have a photograph of that Madras Literary Society? Many of the Chief Justices of the Madras Literary Society is actually one of the oldest libraries in India. And even today, it is a very glorious institution, and much of its progress and much of the credit for the present position that it holds is on account of the Chief Justices and judges of the Supreme Court of Madras. And Henry Davison was also a great supporter of this great institution. Unfortunately, his health was not very good. So he went to Ooty for a holiday. He fell ill there, ultimately passed away in Ooty. He is the only judge of the Supreme Court at Madras to have been buried in India. And there is still a graveyard for him at St. Stephen's Church in Oottakamad. And that is how, sadly, his life came to an end. But he was also one of the most adorable and much loved judges of the Supreme Court of Madras. After the end of his term comes the High Court of Judicature at Madras with Sir Harman Colley Scotland taking over as the first Chief Justice. For a brief period, he was also a judge of the Supreme Court of Madras, but there was a seamless transition when the Supreme Court of Madras became the High Court of Judicature at Madras. So many of the institutions that we have in the Madras High Court are all part of that seamless transition that happened between the Supreme Court of Madras and the High Court of Judicature at Madras. So if you want to understand the High Court of Judicature at Madras, you must understand the Supreme Court of Madras, because High Court of Judicature at Madras would not have existed in such glory. It took off from a completely high level only because of all the hard work that the judges of the Supreme Court of Madras and the Chief Justices of the Supreme Court of Madras did. Principally, they inducted men of integrity, of learning, men of character. Many of them were Orientalists, few of them were Anglophiles, few of them were imperialists, but still they did nothing to spoil their contribution to the cause of justice. So this is the contribution of the Supreme Court of Madras, an institution which is unfortunately largely forgotten, not only by the people of Madras and the people of Tamil Nadu and the people of India, but also the legal fraternity. And it is these roots to which we must pay homage. And as I have said, I've said this earlier, and I would like to say it once again. If you have to ask me, to what did these two institutions, the Supreme Court of Madras and the High Court of Judicature at Madras, owe their eminence before 1947, I would say three factors. Factor number one, the judges were handsomely paid. The intention was to keep judges away from temptation, right? You must understand that the judges of High Court of Madras used to be paid 4,000 rupees a month as their salary in 1862, right? If you tried very hard, you couldn't spend more than 100 rupees in those days. And at times like this, the salary of a judge was 4,000 rupees a month. You today, all over India, have only 1,000 judges, 1,000 High Court judges. It is not going to hurt the government to pay them well. But that will never be done. As much as I say that all these things should be done, I know they will never be done. Because today, the person who determines the salary to be paid to a judge is an IAS officer. IAS officer would not want a judge to draw a salary higher than him. So you have that natural limitation. Second, merit mattered. Seniority did not matter. Even as I told you about the life of many of these judges, I told you that many of them were, many people who took oath as Chief Justice were much younger to even the puisne judges. Even their years of experience at the bar were much lesser. But then the British considered their merit and appointed them, and none of them disappointed the rulers insofar as merit were concerned. So the seniority rule, once again, I don't know, unless the seniority rule is overlooked, we are not going to have the best occupied the highest positions in the judiciary, and that is a sad fact. The third is, which I consider the most important, is let us admit this. High courts, Supreme Courts today are Chief Justice centric institutions. Nobody wants to put his foot down and tell the Chief Justice that he is wrong, right? So they are Chief Justice centric institutions. Therefore, and it was the same in the Supreme Court of Madras and the current High Court of Madras before independence. This is not a phenomenon which is different. But the British realized that if you had observed closely what I narrated, Between 1800 to 1862, the Supreme Court of Madras had only 8 Chief Justices. But you take our High Court from 1947 to 2012, when it had functioned for 65 years as an Indian court, Madras High Court had had 24 Chief Justices. So the average time span for a judge of either the Supreme Court of Madras or the High Court of Judicature at Madras, the period average time span of the Chief Justice was close to 6 to 8 years. Let us admit the fact that judiciary today is a large body. It has a very diverse departments functioning under it. And for a Chief Justice to even understand that institution, it will take not less than 3 to 4 years. And if we are going to have a system where judges only play merry-go-round, musical chair, and are able to sit in their chair for only 2 to 3 years, it is not going to contribute to the improvement of judiciary as a whole. These are the 3 primary differences in the manner in which the British handled our institutions and how we are handling our institutions. I say all this with the hope that sometime somebody will listen to this and we will have some reforms at that level. Thank you, Sriram, for giving me this opportunity.
Okay, thank you very much. What can I say? I'm just shell-shocked at the fact that there is so much of information about the Supreme Court of Madras. And very surprisingly, it seems to have been a melting pot of people from Canada and people from probably the Malaysian islands, which as we know it now. And we required all these people to come together and to form a wonderful institution, sadly about which, as you said, not too much is known now. But wonderful pieces of information.
Thank you.
Great history, great trivia about the fact that corruption was prevalent even now. I was a bit taken in by your reference to C.V. Ranganatha Shastri. If I'm not mistaken, I think Justice C.V. Karthikeyan comes in.
Yes, he's a great grandson of Justice C.V. Ranganatha Shastri.
Okay, do we know the degrees? Because he's sixth, I think, fifth or sixth
generation.
Okay.
You had Sir C.V. Kumarasamy Shastri, who was also a judge of the High Court, whom I think was a grandson of C.V. Ranganatha Shastri. Okay. They were the brothers, both did brilliantly well. And I think Justice C.V. Ranganatha Karthikeyan's grandfather is Kumarasamy Shastri, or must be his great-grandfather.
Okay. So, incredible way in which you have managed to trace. I'm sure it would have been backbending work at one point or the other, though it might have been sparked by a sudden piece of interest or a sudden incident that, stoked your interest. But wonderful, I'm sure it took up a lot of time to get all this in place. It might be easy for you to recount it now, but I'm sure all this...
no, actually, there are very interesting journals which are out of print. But if you go into the Madras Museum archives, Madras archives, state archives, there is plenty of stuff there. And there were also publications like the Madrasiana. There was a journal called Madrasiana, which used to publish a lot of information about judges. There was also the Government Almanac, which had a lot of information. And one other very prominent member of our bar, whom ultimately, who today is not remembered very much, V.N. Srinivasa Rao. He wrote a lot about these judges, and he did a lot of research which has helped me to understand those institutions that existed earlier. He had a very prominent position in the Madras Bar Association, and he wrote he was a barrister himself and wrote such excellent good English and wrote about these people, about the judges and the way of life. There was also a registrar of the High Court called John Shah, who wrote a book on the legal systems that existed in the Madras High Court. Many of them are available in the Madras archives. We are now doing this exercise of trying to... There was also a gentleman called John Paul, who came from America, who was funded by one of the universities in America to write a book on the legal profession in South India. And he did a scholar's work on the legal profession in South India, because he went and sat in the office of the Madras High Court Advocates Association, pulled out all the minutes of their meetings from 1878, much of, at least as much as what they had. Then he went to the Madras Bar Association, pulled out all the minutes of the association. He went to the Madras Assembly. He pulled out all the minutes relating to the legal profession there and compiled an excellent book, the history of the legal profession in South India, which is really a treasure. Unfortunately, only one person had that book, and I took a copy, and I have once again supplied a copy to the Madras Bar Association. Justice Chandru, K. Chandru, and I think even today, Justice Chandru has the best collection of information about the Madras High Court and the judges who existed before the Madras High Court came into existence. But these are so important in our understanding the judicial system. What worked? What did not work? Why did that work? Why did this not working? Unless we do this comparative study, I think we will just be muddling around without any clear solution in sight.
True, but having said that, I'm sure when we get back to physical courts after this lockdown is eased completely, I will never be able to look at a registrar again without thinking of horses. Remarkable, I must say. Remarkable. I mean, I really think that this is something in the school on the moral science as an essential part. I think in law college, one of your subjects should be, instead of legal history being what it is now, I think this is the kind of history that should be taught.
Correct.
At least for information purpose. So
it should be taught in some sort of an interesting manner, right? You need to talk about trivia to get the student excited. If you observe, I have not mentioned a single date in my narrative because people often associate history with dates, and dates are boring, right? So I have, in all these talks that I give, I make a conscious decision not to say this Chief Justice functioned from this year to this year. How does it matter to anybody if he had functioned for 50 donkey years and done nothing? So it is much more important for you to understand what the judge did rather than these dates. So history must be narrated in a way that makes it interesting for the students, and they must understand the significance that it can play in their own lives.
I, of course, beg to disagree with your statement that dates are boring. No, not every kind of date is boring.
I'm talking about it in a formal sense.
Anyway, it was really incredible, and I think that after having seen this, I'm sure there will be a few young lawyers who would be captivated enough by this, slightly interesting and slightly, almost I would say, romantic history that is associated with the Supreme Court and basically the history of our High Court, and probably come forward to help you. And when I'm saying that, I must say thank you to your consent for having published your article on the lighter side of the law. For all those who've not read it, Mr. Rajah wrote, since all of us were extremely busy during this lockdown for the last 3-4 months, Mr. Rajah wrote an article saying, titled On the Lighter Side of the Law, and that's been published on our Facebook page. Please do have a look at it, and please do pass on your comments to Mr. Rajah directly, so that he is entertained enough or he is enticed enough to write sequels for that. Thank you very much. Would you like
Thank you. Thank you,
short?
Thank you.
Okay. Thank you.
Thank you.
Thank you.